Roberto Luzi Crivellini. I'm the co-founder of Legal Mondo, which is a platform of selected independent lawyers from 48 jurisdictions. Our mission is to make it easy for entrepreneurs around the world to find an expert legal advisor overseas and to work together online and off in a seamless manner. So we've been up and running for 5 years, and we are very interested to join forces with organizations which offer synergic services for companies and for professionals who work internationally, such as, in this case, the Chamber of Arbitration of Milan. And I seize the opportunity to thank very warmly Ms. Regazzoni, who is with us today and accepted promptly our invitation to discuss and talk about such an interesting topic as mediation and international mediation in particular. The chairman of this webinar is my good friend Giuseppe Scotti, who is a lawyer in Parma and Milano, a fellow member of Legal Mondo. Giuseppe specializes in litigation, arbitration, insolvency, and corporate matters. So enough said for my flash introduction. Giuseppe, the floor is yours to open the works and introduce our panelists. Thank you.
So thank you very much, Roberto, for organizing this web seminar or webinar, as we define it in these very odd times of emergency. And thank you to the panelists who are participating to the web seminar, and then I will introduce them in a proper way after a few words about the Italian experience of mediation, or at least my experience of mediation. I'm not a professional mediator, I'm a litigator, so I did experience sometimes the mediation, because mediation in Italy is now a sort of mandatory process. Well, it's not completely mandatory, but at least a first hearing before the mediator is mandatory in some cases. So as a litigator, of course, I did experience different kinds of mediation. I was, at the very beginning, I noticed that among the participants, there is also Giovanni Matteucci, is a professor of civil procedure at the University of Bologna. And I found very useful his contribution that I found on the web. And first of all, because it is written in English, so it was quite helpful for me. And I started in quoting a very funny sentence that Professor Matteucci did use for mediation, and for mediation vis-a-vis lawyers, the way in which mediation is perceived by the lawyers is perceived traditionally as a danger, and instead of ADR, the acronym means alarming drop in revenues. So it is true that lawyers, or at least trial lawyers, don't like mediation. And beside quoting Professor Matteucci, I would like also to quote a legendary trial lawyer, Mr. Joe Jamel, known as the King of Torts. And he was proud to remain a trial lawyer, and in an interview to the ABA journal said, and I'm quoting, "I'm a trial lawyer. There are some lawyers that do nothing but this mediation," and then I cannot pronounce the following word, but it starts with B. And do you know what the root of mediation is? Mediocrity. Well, I do not share the view of Georgia Mail, although I'm a litigator, because I found that I did find, and still I find that mediation might be very useful in some instances. Of course, not all the forms of mediation might be useful, but a mediation managed by professional mediators. So just a brief introduction to what happens and what happened in Italy. We experienced 5 different mediation phases. The first one from the late 90s to 2004, with no regulation of mediation service providers, so just voluntary mediation. Then from 2005 to 2011, we experienced a sort of voluntary mediation in certain subjects such as corporate, financial, and banking disputes, and before qualified mediation. Then in 2011, in order to implement a European directive, the directive number 52/2008, the Italian legislator did enact a decree whereby a full mediation process was mandatory and a condition precedent for trial. So we then in 2012, the Constitutional Court, the Italian Constitutional Court, held that the legislative decree was unconstitutional, not for procedural reason, and so we got back to voluntary mediation again, and then again to a sort of recast of mandatory mediation. But this time, mandatory mediation is a kind of misnomer in the sense that only the first hearing before mediators is mandatory, and then is not, of course, compulsory the entire, the full-fledged procedure. So we did experience 5 different kinds of mediations in Italy, from voluntary to mandatory to a sort of hybrid, where just one step is mandatory. And at the end, mediation proved to be quite successful because we had a drop in the number of cases litigated before the court. And according to the European Parliament, Italy, and I'm quoting, uses mediation at a rate 6 times higher than the rest of Europe. So at the end of the day, although probably we didn't have a culture in mediation, through all those steps, we have now a system, a mediation system, that does work, at least as statistics are at stake, in an efficient way. Before presenting and introducing Roberta, have a breaking news, because at the meeting held on 17 June, the Senate approved a Macchi amendment on the conversion into law of this famous decree number 28 of 30 April 2020. And this amendment contained an article aimed at providing for the experiment of mediation as a procedural condition, also for disputes concerning contractual obligation in which compliance with the measures enacted during the emergency has delayed or omitted performance. So we now have a different kind of mediation for the disputes that will arise because of the COVID-19. So this is the news, the breaking news, or at least dating back a few days ago. So first of all, we do have as our keynote speaker Roberta Regazzoni, and Roberta is graduated in law at the University of Pisa She's in charge of the Dispute Resolution Board service at the Milan Chamber of Arbitration. She's also in charge of the international promotion of the mediation service and the Italy-China Business Mediation Center. She is responsible for managing relations with the European institutions, in particular, DG Justice and DG Internal Market. So the title of the intervention of Ms. Regazzoni is International Mediation in Italy, Lesson Learned. I have a first question for Roberta. Thank you, of course, for participating. I'm very happy for this collaboration with such a prestigious institution as the Milan Chamber of Commerce. And the first question is the following. I try to briefly outline the Italian model. Is it appealing for international disputes?
So, thank you, Giuseppe, for your spontaneous question and for inviting me there to talk about mediation. Actually, international mediation. As you perfectly spoke about the, all the saga of the Italian mediation, I must say that as per myself, the Italian system has a lot of good points. From my part, I mean, as a person in charge of the International Mediation Service in Camera Arbitrale, at Camera Arbitrale, I see some bad points. For example, the Italian system is has been conceived as a top-down approach. So we have a very detailed legislation in place for mediation, and it touches also the training of mediators and also the entities that can provide mediation services. So in Italy, we don't have freelance mediators, for example, as in the UK and US. So a mediator to work has to be part of a mediation provider. The mediation provider has to be approved by the Ministry of Justice. And also the mediation centers for training has to be approved. So the outcome of this very detailed system is that it is difficult to find non-Italian mediators for international proceedings. So actually we have a lot of good mediators. They are most of them are perfectly capable to perform mediation in another language like English or French. But normally, even though mediation is different from arbitration, in many cases, the majority of cases, the international parties want a mediator of third nationality. Even though the mediator is not a decision maker like an arbitrator. But since mediation is a matter of trust, independence, neutrality, and so on, they ask for a third neutral with a nationality which is not Italian. So what can I say is that the Milan Chamber of Arbitration was immediately aware of this point, because the users came to us asking for a mediation that wasn't under the rules of the Italian system, because they wanted a mediator who wasn't Italian. And also they wanted rules not so strict, so a sort of proceedings not so formal as provided by the Italian law. For instance, you know that each time you meet during a mediation proceeding under the decree, you have to sign the so-called minutes. Actually, it is not what's happening during this meeting, but they state who are there. So they have the mediator and the officer has to state who is sitting at the mediation table, who leaves, who is coming in, and also the outcome of that meeting. For example, the mediation is adjourned too. So we had some parties in international proceedings. They didn't want to sign anything. They wanted the absolute confidentiality of the process. They wanted a mediation like is performed everywhere except for in Italy. So very free with the rules, very simple, only few articles stating the basic principles of mediation, because the proceeding is in the hands of the parties. The parties make the rules of the game, right? So we came across these people asking for a different service, not the mediation stated by the law. And we decided to publish these fast-track mediation rules, which are very simple, informal, and we also have a list of international mediators, Italian mediators, but also mediators from other nationalities. And we also signed some agreements with other institutions like us, like the CEMAPE in Paris, or the CPR in New York, and we exchange mediators in case, you know, the parties want to have a mediator which is not in our official list. So it's a very, how can I say, tailor-made proceeding. We talk a lot with the parties before starting the mediation. We try to see what they need, what they want, what they expect from mediation. And we try to sue, you know, like a tailor, their own proceedings.
Sorry, I'm mute. Thank you very much. And it seems to me that the device you have mentioned, the fast track mediation, is quite interesting. But I know that beside the scheme of fast track mediation, the Milan Chamber of Arbitration also runs a mediation service devoted to business disputes between Italy and China. Could you briefly explain to us why this particular service that you have conceived?
Yes, thank you for the question. This is another thing coming from our users, because the chamber started with the mediation in 1996. So long years ago, long time ago. And it happened to us to have Italian companies trying to invite in mediation Chinese companies. And we treated these cases like all the other international cases. So we sent emails or registered letters and so on. But it was really rare to have a Chinese company sitting at the mediation table. In my, well, I started in 2000, and I don't think I'll never saw a Chinese party sitting in a mediation room with the Italian company with that system. And this is, I think it's understandable, because the Milan Chamber of Arbitration is one of the hundreds of institutions providing mediation and ADR services around the world, and Europe and China in this are not so well aligned when it comes to knowledge of providers of those kind of services. So we decided to get in contact with the CCPIT Mediation Center in Beijing. CCPIT is, first of all, I must say that the Milan Chamber of Arbitration is part of the holding of the Milan Chamber of Commerce. And we normally go to our sister institution around the world. So we look for this kind of alliances. And CCPIT, it's a sort of super mega chamber of commerce, Chinese Chamber of Commerce. They have offices in all the cities, big and also very small in China. So they are very in the territory. They are very renowned by the Chinese people and Chinese businesses. So we went to them and we signed an agreement. We tried to make this agreement as efficient as possible, because sometimes you sign agreements, but then it's just for promotion or to promote together something, etc. This one, since the beginning, was meant to be very operative, very effective. And so when it happens that an Italian company has a problem with the Chinese counterparty, then they file the mediation request in Milan. I send the mediation request to my colleague in Beijing, and they contact the Chinese company, which is very, how can I say, it goes through much more easily because they contact their people. So there is also a, they can, the Chinese company can receive information about the proceedings in their language. And this create trust, you know. So the fact that you are running a mediation under an umbrella made and run by two institutions, so two nationalities doing the same thing, this creates a lot of trust in the tool, in the proceeding. So it's much easier then to have a mediation proceeding between those two nationalities, that they have a very different cultural background and views, and maybe Alessandro will talk about it later. So it's a very peculiar service. We do not have so many cases. It started in 2005, and maybe we have covered 100 cases, not more. But even here was very tailored on the needs of the parties. And another thing that perhaps could be of some interest for the participant is that we try also to use co-mediation. So we pick an Italian mediator and a Chinese mediator, and we put them together following the case. Obviously, they both have the skills of conflict management that the mediator should have, but they also have intercultural skills, because during over the years we also trained them with the specific training, with the specific eye and focus on interculturality, which is very important, of course, both in trade and mediation, which is trade-like.
Thank you, Roberta. Final question. Giuseppe, if I may.
Yes.
I have a spontaneous question. Out of those 100 cases, roughly, what's the average of successful mediation?
I can tell you something. This is also very interesting, because I have noticed, I'm just speaking my point of view and my personal experience. So my point of view is that the Chinese party doesn't like formal engagements very much. So we have solved the majority of these cases simply by exchanging proposal and make direct negotiation between me and my colleague, you know, without a mediator. And the most complicated case is that in that case we saw it was a skilled mediator was needed. Actually, I can also tell you something, but I think this is not a feature of mediation, but a feature of the Chinese way of doing business. In many cases, the Italian party doesn't have an idea of the person who is talking to, meaning that in China, the intermediaries are very used in the trade domain. So actually, the Italian party think of having a problem with the person who is not producing anything, but it's just intermediary. But it's not. There is a low level of transparency, even in trade, not only in mediation. So actually, yes, the majority of the cases have been solved informally, even more informally than using mediation with a mediator and so on. I don't know if I replied to your question.
You did.
Okay.
So if Roberto does not have any further spontaneous question, I have my final question for Roberta. The Singapore Convention on Mediation. The convention is aimed at achieving universal recognition of mediation and will entry into force in September. Neither Italy nor Europe are parties to the convention. But I know that Mr. Azzali, who happens to be Secretary General of the Milan Chamber of Arbitration, participated in the works at Ancitral for the cross-border enforcement of mediated settlement. So can you make a comment about that?
Of course I can, and I know that this is a topic which is very good also for Giovanni Matteucci, because today we had an argument on it. So we have different views perhaps on that. And so, yes, Mr. Azzali was one of the observers during the works at Uncitral. They were very long and very debated. And the majority, let's say the pure mediators, don't like. I can see the Giovanni Matteucci chatting on the chat. So the pure mediators generally don't like this kind of convention, because they think that is something that Uncitral made to boost mediation, but in a certain way, you know, to make it closer to the New York Convention for the arbitration awards. And actually mediation and arbitration are two different things. Arbitration is legal, mediation is business. This is my opinion and the opinion of many other people working in the sector. And I think that the convention could boost mediation, the knowledge, the culture of mediation around the world. I think it could be a good marketing tool for mediation, therefore. But I also think it's a bit risky also, because somehow it makes, for example, it puts mediators in a very bad position, because everything relating to mediation should be absolutely confidential. And for example, the convention states that, first of all, this convention applies to mediated agreements. Okay, so who is telling the judge this is a mediated agreement? Who states there is a declaration by the parties? The convention says that the mediator can sign the mediation agreement in order, you know, to tell the judge, state to the judge, just in case, that this is a mediated agreement. So there are some shadows, let's say, on this convention. And last point, and probably the most important, I think I never heard about a mediation agreement, both national or international, domestic or international, that needed to be enforced. Because generally, since the signature of the parties is voluntary, it's a consensual tool, it's a consensual proceedings. Generally, who signs then complies, right?
Thank you very much for your bright and very informative intervention. I think that we should have some room at the end of the discussion for a Q&A session. But now thanks again for your intervention, but we need to go on and pose some spontaneous questions to our second speaker of the day. Probably I forgot to specify that if you have questions, you have to raise your hand through the device that you will find on the screen. This is a web seminar format, so we do not see each other. So Ignacio Alonso. Ignacio has been working for more than 25 years in the fields of distribution, agency, and also in the corporate field. Is a commercial mediator and is a registered mediator at the Mediators Registry of the Spanish Ministry for Justice. Ignacio is fluent in several foreign languages. I can tell you that speaks a perfect, splendid Italian. My warmest congratulations to Ignacio for his Italian.
Thank you.
So unfortunately, this seminar is in English, but if it were in Italian, Ignacio could have displayed a perfect Italian accent. So I have the first question for Ignacio. The title of Ignacio's intervention is Mediation and Distribution Agreements, Termination and Way Out Clauses. So the first question is, in which situation of distribution agreements can mediation be used?
Okay, thank you very much, Giuseppe. Thank you, Roberto. Well, I will start straight to the point. Mediation is a very useful tool in conflict, for solving conflicts in distribution agreements. And when I say conflicts, I do mean conflicts, not cases before court or judges. Conflicts and cases are two different things. There is, in fact, a question that I like to ask to my clients, usually medium and small companies. And I usually start asking, what do you prefer, to win your case or to solve your conflict? Because some of the times, most of the times, both questions, both are not the same. Let's start with an example. Let's imagine a Spanish manufacturer and an Italian distributor. Their agreement has lasted several years. They are running quite well. And at a certain moment, the manufacturer decides to terminate the agreement. It sends a letter to the distributor saying, okay, you have, usually he says, okay, you have breached the contract in that point, so we will terminate. You are not allowed to get any compensation at all. That's a quite frequent situation in distribution agreements. Of course, the distributor will say, okay, but I have these rights, and they start exchanging the letters. Yes, but you did not respect that point. Yes, okay, but in the past you accepted the way we behave. Yes, but now you have not respected, and you have to compensate. So that's a very quite frequent situation in which, when we arrive to this point, it is most probably impossible that for the parties to get a way out. And the only possibility seems to be to find a judge or an arbitrator. That's the first example. Let's imagine a second scenario, a similar situation with a Spanish manufacturer and Italian distributor. They are acting quite well, they are very happy, they are making business. And what happens? COVID-19 arrives. And we all know what happens until now. General lockdown, shops are closed, clients do not buy, stocks remains at the premises, orders are cancelled. We know quite well our current situation. Parties in this situation, in this scenario, want to continue, but they don't know how to continue. They are facing a new situation completely different. And if they try to use their contracts, when they have a contract, because it's quite frequent not to have a contract in distribution agreements, if they only want to use their contracts, they will not find the solutions in the contract. And this is particularly true in international trade, because most of the times we start our discussion by deciding which sort of agreement do we have. Is that an agency agreement? Is it distribution? Did we start with a distribution agreement, then we transform into an agency? It's a sort of franchising with some elements of agency agreement. So we do not know our situation, and we have to face this new pandemic and strange situation for everybody. And here the elements of the lawsuit, the case before the court or before the arbitration, are usually the compensation. The distributor wants to get his compensation for the termination of the agreement. But if we are in this COVID-19 situation, what can we do? Do we have to respect our clauses? Do we have to go directly to a judge? And these are the elements of the case from a judicial or arbitral point of view. But the elements of the conflict usually go beyond what is the surface of the case. And if we go deeper in the situation, we will find some elements, and some very different and very important elements, which also are interesting for the parties. For example, the fact of being accused of breaching an agreement can be of importance for the distributor. For example, the reputation for the trademark or the brand, the continuity of the business, or for example, not to have influence on the teams inside the company or the rest of the network, the problem or the shadow of the bankruptcy. Judges in these situations are not able to decide on every aspect of the conflicts. They usually propose they impose a solution, usually based on legal aspect, but they do not solve the conflicts. And that's why mediation in situations like this one could be of great help, because they can offer a solution to the problem and they can help the parties to find by themselves the solution.
Thank you, Ignacio. It seems to me that you are very much in favor of mediation. But let me ask something. Which are, in your opinion, the pros and cons of mediation if compared to judicial or arbitral procedures? And another question, I was curious about which is the attitude of the judiciary towards mediation in Spain, because we said a couple of things about the attitude of lawyers in Italy, but which is the attitude of the judiciary?
Okay. From one side, the pros and cons of the mediation, more or less I have already said something. The arbitrator does not impose a solution, but the mediator does not impose a solution, but just helps the parties to find it. So it proposes a very flexible way. Roberta said before, is the flexibility which is interesting here. Mediation can be adapted to the situation, to the parties, to the market, to the distribution structure. For example, is that, online, offline, omni-channel, the different seasons depending on the products. Is that a franchise situation, for example? Even cultural, we have seen the example with China, and Alessandro will help us to understand a bit more. So in this situation, mediation can offer confidentiality to the parties. I am happy to see that in Milan with the Chinese, the confidentiality is so important that they don't want even to be mentioned in the document as a part of a mediation, and that's interesting because some parties do not want any publicity at all, not just bad publicity, but any publicity at all. They don't want to be mentioned as a part, but it's of course faster, it's of course less expensive. It avoids blocking money in courts. I have known today that in Spain, we have 4.4 billion euros blocked in courts because attending, depending on a final decision by the judge, 4.4 billion euros. That means that this money is not acting in the economy. They are blocked in courts waiting for a judge for a decision. Of course, mediation can be followed online. It solves all the parts of the conflicts and not only those legally related. And very important, parties remain in control of their problem. They are the parties are the ones who can decide and arrange and imagine the solution of that problem. And that's why, and I agree with Roberta, agreements reached in mediation are more likely to be respected because parties are part of this solution. They are drafting the solution. They are not just receiving what a judge or an arbitrator has decided, and then they have to decide, well, I will comply, I will not comply with that decision. So you are also reducing the problems of enforcement. And what's the judge says about that? Well, here the answer can be very different because there are judges very pro-mediation, and they like very much sending cases to mediation or trying to have mediation before their decisions. There are others that consider that mediation is not real justice, so they are very much afraid of the evolution of mediation. Officially, judges are pro-mediation officially, but there are some of them which are not very happy with the solution because they see that not as a risk, and there is also a problem with judges because judges, at least in Spain, they are paid in function of the number of judicial judgments they produce. So when there is a mediation, the number of resolutions they decide decrease, so they get less money for that. So they are not very happy sometimes in sending sending cases to mediation. I don't know if that's cons of the mediation. There are some. Not every case, or not in, for example, in distribution cases, not every case can be solved by mediation. For example, the problem, there are some situations in which conflict has so much escalated, so we have so big conflict between the parties that is almost impossible to get a solution just talking the parties or just by these techniques. Mediation requires a lot of responsibility by the parties because they are very much involved in the solution. So sometimes parties do not want to be involved in the case. They prefer to say, okay, I give that to my lawyer and I will have the answer 3, 4, 5 years ago from now, and I'm happy about the solution. I'm not happy, but anyhow, I don't want to see my counterparty again to try to solve the solution. So it's not a perfect way, but of course, I think the pros are more than the cons in this case.
Thank you. I think that in Italy, judges were at the very beginning very reluctant in accepting mediation. Now they better understand mediation as a very powerful device, and they are more in favor, even because through mediation, the number of cases is dropping, and they are happy for that. They are not paid based on the number of judgments they write, so they are better off if the number of cases dropping. So, but at the beginning of your very lively presentation, you were mentioning the typical conflicts that might arise upon termination of an agency or a distribution agreement. From a practical point of view, how mediation can help in solving those conflicts?
Okay, here we can make a difference between a termination situation where the parties just want to terminate their relationship, or a continuation situation where the parties want to continue the relationship. In both scenarios, I think mediation can provide interesting tools for the parties to solve their conflicts. I insist in the difference between conflict and judicial case, for example. In the termination scenario, mediation can help the parties to go beyond the interests, to go beyond the positions they show in the before the judge, for example. When you have to terminate an agreement in a distribution case, you usually ask for a compensation if you are the distributor, or you just want to terminate the agreement if you are the manufacturer. But usually, beyond these positions, there are other interests of the parties. As I have mentioned before, there are, for example, the interest in how to close the relationship that, for example, has lasted several years, or how to be recognized for my work as a distributor in order to restart in another position, or how to offer a future for my children which were working in my company as a distributor, or how to manage the distribution network. I don't want, as a manufacturer, that this agreement, which is terminating, affects my distribution networks. So in this situation, a mediator could help the parties to go beyond what they are just putting on the table before a judge. So that's a very interesting element, because sometimes my compensation as a distributor is not my main concern. Of course, I want to get to have some money, but it's not my main concern, or is the first one, but I have also other interests, very important, that I would like. And sometimes I could even renounce to some part of my legally compensation in order to get some recognition, a job for my children, something that could be put also into the negotiation table. And in a situation where both parties want to continue, the example I put with the COVID-19, mediation can also help very much in renegotiation the situation, the contracts the parties have. So they can help them to understand how to face these situations that nobody before could have imagined. So how to react and how to face the emotional elements, the fears they have about themselves, about the clients, what to do about the stocks. Can we offer to the parties a more, how can I say, less adversarial approach in order to collaborate in this new situation? How can we imagine a possible breakdown of the pandemic in the future? Can we set some basis for a future new problem? And there is a third possibility. For example, when the parties they are not sure what way to follow. Do we have to terminate our agreement because the circumstances, our agreements are not useful any longer, or can we explore new possibilities, a different way of relationship? So mediation is very flexible. The nice thing of mediation is that it's very flexible and is not blocked by what the law says about a specific question. Of course, the parties are assisted by the lawyers, so they know their rights, so they are not in a sort of desert just with the mediator, with the stronger party. No, no, they are assisted by the lawyers. The lawyers can advise the parties very well about what to do and what not to do, but they can find by themselves what are really interesting for them. I would like to finish with one sentence that I like very much from Stuart Levine in a book known called Getting to Resolution, Turning Conflict into Collaboration. Stuart Levine says, and I'm quoting, "If you go to court and continue to do battle, you will end with a new agreement. The terms will be dictated by a judge who knows very little about your situation. The decision is likely to be far less workable for each of you than one that could be designed by both of you." So the collaboration of the parties is much more interesting, if possible, of course, and the parties will remain always free to say, okay, mediation has not worked. We still have the courts to solve our conflicts.
Well, thank you very much. I did like your very passionate way of advocating in favor of the mediation.
That's my personality.
No, that's perfectly fine. But I noticed that at the very end of your intervention, you did point out and you stressed the role that mediation might play not only in resolving disputes, but also and more in general in deal making. We might come back to this notion later if we have time. But now it's time to revert to our last speaker, Alessandro Mazzi. And Alessandro is an international legal consultant, is based in Amsterdam, and specializes in tech startups, international contracts, intellectual properties, data management, blockchain projects, and initial coin offerings. Alessandro graduated in law at Bocconi University in Milan, and his studies are mainly focused on alternative dispute resolution and international commercial law. The title of Alessandro's presentation is "The Importance of Considering Different Perspectives in Cross-Cultural Mediation." We have already talked about cultural issues when we were discussing about business disputes between Italy and China. You will treat about cross-cultural mediation. And can you define the notion of perspective taking, and in this respect, and why perspective taking is so important?
Sure, and thanks to everyone. I really enjoyed the talk so far, and I'll try to sing along with the same enthusiasm as Ignacio had. Just to build a bridge between what has been said already and what I will be talking about regarding to Roberta and the education about intercultural mediation. There is a IMI, which is the International Mediation Institute, that is already certifying mediators on intercultural mediation itself. So it is a world that is developing and is trying to get mediators really prepared in that topic. So a perspective taking, well, let's define perspectives is basically the view that someone, an individual, takes about something. So it's, imagine it, I like to use the metaphor of a lens. So the lens, the worldview that someone takes towards something. And perspective taking is, I would say, the skill that a mediator would need to understand the party and look through that lens that they're wearing to be able to then work with them. Also, perspectives are very important for the mediator to understand what is their lens they're using, because you probably know, Giuseppe, we talked about it before, that a lot of mediators have the bias of trying to find a solution, because that's their main job. And then when they find themselves as being a mediator, they're trying to advise the parties on what is the best solution that they can find. But the role of a mediator is to help the parties find their own solution, like Ignacio very well explained. So that's one part. On the perspective taking from the mediator side, it's very important, again, to understand the interest of the parties, because the parties come to a mediator to be listened and understood and to find their own interests. So the Harvard negotiation courses teach a lot to mediators and negotiators how to move the parties from their positions to their interests. So the positions can be defined as what the parties say they want, and the interest is why they want it. So if the mediator has the power to understand, or the capacity to understand what is behind a party motivation to want something, then they can help. With the why question is a very powerful one, but with other open questions to understand why did they come and hopefully find a solution. But that's the odd thing that I found out when I started to be neutral between parties in a conflict. Sometimes it is not always about a solution to be found. A lot of times the parties don't really want to be together again, but that interest has to be theirs and has to be communicated clearly. Perspective taking is also powerful on the side of the parties. So sometimes it's a powerful tool to give to a party to make sure that they understand this, especially if you have a one-to-one conversation during a caucus session with one-to-one with only one party, to try to make them look through the lens of the other party. I guess this also brings me to the point of which I think you, Giuseppe, mentioned, that mediators, to be effective mediators, need to go through quite some training, and also Roberta said it. It's to take perspectives takes a lot of training. You have to understand your emotional reactions and understand in an intercultural setting even more what is the driver behind the parties. And this is an exercise. It takes training. It takes a lot of studying, which goes beyond law and beyond even commercial settings, but more into the psychology of the disputes. You're muted.
Sorry, I have to unmute first. You did mention Harvard, and I want to tell you that during this emergency period, I was attending a very nice course taught by Professor George Siddell, which is based on the Harvard course on negotiations. The title is Successful Negotiations, and at some point you learn some very specific terms such as but now or what now, or but you don't want to pronounce ZOPA when you have Russian lawyers or Russian students, because it means a very bad thing. So then you will look into the dictionary. So I mean, cultural issues can also those kinds of issue. But beside this very interesting course, that the second question I have for you is, how does perspective taking relate to the realm of intercultural mediation?
Yeah, so from my experience, well, culture means quite a lot of things, especially in this international global world we live in. But let's say focusing on national related culture, let's say culture gives us, knowing where someone comes from gives us some sort of a guideline of knowing who we're talking with, so to know again from which lens they might be looking through. And I was happy that Roberta also mentioned the fact that intercultural, international mediation disputes, they are already trying to come together with the parties before even the mediation starts. So before the mediation, trying to understand, first of all, who the parties are, where they come from, what is their understanding of mediation and the role of the mediator. Because you can use quite a few models, but I like the Hofstede cultural dimension theory, and where he explains basically how national cultures, how they differentiate from one another. And some cultures might think that the mediator, because of a very strict hierarchical structure that they grew up with, might be the person that needs to decide. And they might not speak up so much during the mediation, but let the mediator talk, or be very submissive towards the other party. So I guess it's being aware of cultural dimensions in a mediation is very, very important, and also to know what the language to be used. You mentioned the Russians, but like there are many other examples, like let me think of the Chinese. Like my experience was that when I worked in China for a few months, that you never raise your voice. And coming from Italy during a discussion, even if it's like a peaceful discussion, we tend to raise our voice, and raising the voice, and Roberto knows it very well, I guess, means losing face, means losing control, and therefore losing your, the other's party respect, for instance. So being aware of it as a mediator is very important, and I guess acknowledging to the party the fact that they come from a different culture, and also again looking back at taking perspectives, trying to facilitate a conversation between the two parties so that they both understand that there is a cultural difference. That might mean also language-wise that some things might be interpreted in different ways. And this again is something that the judicial system cannot really offer. It's not the role of the judicial system to offer these kind of conversations that again are constructive towards kind of facilitating the parties to come with their own solution.
Thank you, Alessandro. I was mentioning Russians because, as you might know, I have quite an experience being my wife a Russian citizen. So that's why I was quite aware when talking about zone of potential agreement was quite dangerous if pronounced as I did before. But coming back to your own experience, is there an example that you can infer from your own experience where understanding cultural implication was helpful in order to solve or fix issues?
Yeah, so So here in the Netherlands, I quite often encounter what again this Hofstede cultural dimension theory will call the conflict between collectivistic and individualistic cultures, and which is very interesting because in the Netherlands, a lot of people from North Africa or from the Middle East, Turkey, immigrated. So you have now first generation citizens who are fully Dutch, but still inherit strong parts of those cultures, which are more collectivistic, and the Dutch culture is more individualistic. And so once I was called in to be a neutral between a conflict over a partnership where there were two Dutch, but one of them was, his family was from the Middle East. And what came apparent quite soon was that the Dutch party, the fully Dutch party, I don't want to be incorrect with that, the fully Dutch party, I would call it, or Party A, was talking through using the word I a lot in the partnership. So I think this, I think that, I am in this partnership for this reason, blah, blah, blah. And the Party B was more talking from the we perspective. So from the partnership being him in a way, and how that was perceived from Party A was this guy cannot take his own responsibilities on this. It's just blaming everybody, but he cannot take his own responsibilities. And from my side, coming also from an individualistic perspective, this was the first signal. But then I thought maybe let's try to get more behind what's real. So during a one-to-one conversation where he shared more about his interests, it really became apparent that this was his way of seeing the partnerships as a whole and not as like two divided individuals, let's say, or companies in the case. And the way I brought the conversation back between the two was to convince Party B of the fact of like, okay, I understand that you see the partnerships as a we, but try to see your role in that tribe, basically, and define that role. And when he was able to shift that in the conversation with Party A, then he was able to find where he was actually not acting, and he was starting to talk from an I language, which really helped then find an agreement where he listed basically the things he was going to do in the next months to be able to bring the partnership forward. Another example comes from my Chinese experience, whereby it was the first time I actually saw such a big cultural difference, whereby the partner I was working with told me that in China, a lot of times you're talking to a person, but there is a whole world behind them that is actually guiding what they're saying. So for them, it's very hard to take what I would call a first-person perspective, where people say what they think, but it's usually taking whatever is behind them, can be not just the company, but the neighborhood they're in, or the families they belong to, the wider families they belong to. So that was a very big realization that made me think like, okay, making deals in China, negotiating in China, mediating in China is something different than what I thought it would be from my European point of view. And then to conclude is, yeah, I think, so using these differences to create something new, to get the creativity out of a dispute, I think it's very important. So it's not about being neutral and being always accepting, but it's about, like in the example I've given, to take those differences and try to take advantage of it throughout the mediation to come to a creative outcome, let's say.
If I may add a word, thank you, Alessandro. That was very interesting. I think it's very interesting the point where you define the role of the person and who is behind in the organization. So I happened a few years back to manage to close a mediation between a Chinese party who was my client and an Italian counterpart. And the reason why it was so difficult to reach to an agreement was that my client seemed to be very reluctant to accept what I thought were very easy and no-brainer solutions that would close the matter. And finally, what I understood at the end was that he was very concerned that he would lose face, he himself, in front of his organization. So he had to find a solution which was both good for the company and for himself, who was the person in charge of the negotiation. So at the end, when we were, I was not an expert in mediation, I'm not today, but he managed to tell me when we had enough trust between ourselves, say, look, Roberto, it's, this is not acceptable because then I'm screwed up here. So it's good for the company, but I lose face. So that, I think that might seem trivial, but it might lead to a successful mediation or not. So understanding the what's at stake for the person in the room is key to me.
Thank you, Roberto. I think we are quite on time. So can you confirm that we have room for a Q&A session, or?
I believe so, yeah.
So if we have some questions from the audience, I don't see any question.
Everything was clear.
Was crystal clear.
But maybe one question or comment for Ignacio from my end is that I've been into a very similar situation to which he described. But it was on the contrary with the Italian manufacturer and the Spanish distributor, and I had been in that contract for 28 years. Imagine that. And so at one point, the Italian manufacturer, out of the blue, decides to terminate the agreement. And that was out of an acquisition from a multinational company, as it's often the case, which already had its Spanish distributor. So, there was no room for two companies. So I came into a picture when we had interim measures in Italy not to terminate the agreement. Another case, and a criminal case also filed in Spain, in Madrid, for the same reason. And the two orders from the two judges were conflicting with each other. So one said, I reject the petition, the motion, and the other one, the Spanish in this case, said, yeah, I order you to continue to supply the products, and if you don't comply, you can go to jail for this. So in a very complex situation, when I talked to my client and we finally figured out an agreement, he said, well, I didn't know that we could go to mediation because it was not in the contract. So the first thing I did was to go to a lawyer and then to seek and to go to court. And that, mediation kicked in several months later, and we managed to close it. But I think, I wanted to know what's your experience, Ignacio, that a good clause, mediation clause that, at least reminds the parties that there is such option before they, start, a legal battle, would be indeed interesting, at least as a reminder that this option is there and it can be very, very interesting for them. I don't know what's your
Absolutely
experience.
agree. Yes, the problem with the mediation clauses is, as we all know, as lawyers, these jurisdictions and applicable law and mediation clauses are the last minute clauses we deal in an agreement. So when everything is almost closed and everything in an agreement is almost agreed, one of the parties say, okay, but let's submit this agreement to the which sort of jurisdiction, law, arbitral tribunal, and mediation. If it is not very well known by the lawyers, it's very difficult to have it as a clause in an agreement. It's very useful because, as you say, It reminds the party that there is this possibility. But even if you don't have a mediation clause in an agreement, parties can agree after, when the conflict arises, that they decide to submit. Of course, it's more difficult because at that stage they have to choose the mediation institution or the mediator, the language, the premises, the places, and so on. So it's better to have it done at the beginning. But if you don't have that on your agreement, you can also, if you are able to convince the other party to go to a mediation. And I say, if you reach to convince the other party, because sometimes mediation, and that's a problem also, is seen as a weaker position. I mean, if you propose mediation, the other part, you don't want to propose mediation when you have a conflict, because you don't want to be seen as a weaker party in the conflict. And when you propose mediation, it seems that you are not right in your legal position. So that's why you are proposing mediation. And that's a question that you have to forget completely. I have proposed many times mediation in conflicts that I have won at the end, and that was not the problem. The problem is not for my client to wait 4 or 5 years for a final solution, when you can have it in a quicker way, much before any conflict gets bigger. The problem sometimes are the lawyers, and I am not tired to say that in whatever meeting I participate. The problem with the mediation, in my opinion, a big problem or a problem, are the lawyers who we believe that we know what is mediation, and we think we are all mediators by nature. Because we are lawyers and we mediate all of our life, but that's not true. And I think a mediator has different tools and different elements to help the parties to solve the conflict. A lawyer is very good to keep the parties into the legal frame. But a mediator can help very much the conversation, the negotiation, and so on.
Roberta, do you wanna
yes.
add your comments on that?
Yes, I wanted to comment this because I didn't know if Giuseppe mentioned it, but when mediation, there was the first draft of the law. Italian lawyers went on strike twice against the mediation law. And actually, at the moment, at least in Milan, things are shifting in the good way, meaning that lawyers now, they understand more, and also they train to be lawyers inside the mediation meeting. So I personally believe that in certain situations, lawyers are fundamental, first of all. And secondly, the first person, the first reference of a person who has a problem is a lawyer, at least in Italy. And they could bring parties in mediation in a different way. So more, with more knowledge and in a very conscious way.
I'm very happy to hear that, Roberta. I'm very happy because we in Spain, we are looking very much the situation in Italy, both for cultural or similarities of our countries, and because we are not used to mediation, so you weren't, and because tomorrow ends our attempt that we have from the Ministry for Justice to make comments on a proposition of law to have the mediation more active in our legal system. So we are always talking about the Italian situation as a model for our mediation evolution here. So that's very interesting.
Look, I think it's a work in progress.
Yeah.
So you don't expect to have all the lawyers by your side and to understand perfectly what happens into mediation. It is very nice to see how they are gobsmacked when they have a mediation developing under their eyes, and they understand what's going on and what's the real role of the mediator. This is very nice to see. It opens your heart after years of,
we will keep,
you know.
We will keep in contact, certainly.
Of course. Thank you.
Thank you.
I think that we do not have any other question from the audience. So it is now time to thank the participant and to leave the web seminar. Many thanks again to all the panelists and the participants, and let's see whether mediation will be appreciated better by lawyers in the future.
Thank you very much. I hope so.
Ignacio will tell us in the next webinar what's the situation. Aid from the Spanish front.
Thank you. Thank you.
Thank you. Bye
Thank
bye.
you to all.
Bye. Bye.
Bye. Bye. Bye. Bye. Bye.